Excellent. Hello, hello. My name is Jenny Casson. I'm the chair of the board of the Crowdfunding Professional Association, and I'm excited to welcome some amazing experts today to talk about one of the really important parts of regulation crowdfunding, which is the post-raise compliance. I actually just finished a raise myself. So this is on my mind. I'm also a lawyer, so I've had some clients having to do this post-raise compliance, and I know it's super challenging. So hopefully we'll gain some really awesome insight today about, what's happening, how many people are actually complying, what are the consequences of not complying, what are the requirements, how can we improve things. So I'm going to let the panelists introduce themselves. So let's start with Charlie.
Hi, everyone. Charlie Guidry here. Pleased to be here. Nice to meet everyone. I I, in at the end of August, I wrapped up a 10 plus year at the SEC and started off on my own. So I've been in the background of all of your conversations on crowdfunding and other exit markets. So I'm excited to be here.
All right, and Greg.
Hi everyone, Greg Burke here. I'm a professor at Loyola Chicago, accounting professor over here. So not a lawyer, but a CPA. My background and contribution to this conversation is research around crowdfunding and specifically the AR compliance and investors' use of those reports, as well as issuers' compliance behaviors. So happy to be here.
And Peyton.
Hey everyone, my name is Peyton. I am the COO at Raise Papers. Our mission is to educate and empower platforms and founders raising capital with a simplified, user-friendly technology to draft forms like the Form C and the CAR, file and stay compliant with the SEC. That's it.
Awesome. Great job being brief, everybody, so we can really dive into the meat. So we're going to start with Charlie. So Charlie, you have a lot of experience with these regulations. So please tell us, not everyone who's online today or listening to the recording knows even what the post-raise requirements are. You might get all excited about raising money using regulation crowdfunding and not even know what those requirements are. So as a starting point, just give us the basics on what is required.
Sure. Yep. Not a problem. So after you've done your raise, you do have an ongoing reporting requirement. And the good news is that it's very similar to the Form C that you use during your offering. And so you sort of keep that in the back of your mind. A few things and we've used the term Form CAR. AR just stands for annual report, and that's what you need to file as part of your ongoing reporting. When is the CAR due? Well, it's due within 120 days of your fiscal year end. And if you're a calendar year end company, I believe that's April 30th of this year. So that's the first thing, when to file within 120 days of your fiscal year end. Where to file, you file both on Edgar and you have to put it on your website. And so that's an interesting quirk of reg crowdfunding when the commission put it together in 2014, 2015, use of your website was very important as a communication device for you communicating with your investors. So both on Edgar and on your website. So what needs to be in the CAR? Here's some more good news for you. In general, you need everything in your CAR that you had in your Form C for your offering. But that's in general, but a few caveats. The first one is, of course, another fiscal year has passed, and so you have to bring all of that information forward. So that's the first thing. And so that means you have to have the two most recent fiscal years. So we're in 2026 now. When you file on or before April 30th, you're going to have 2025 information and maybe some 2024 information. So that's step one. Two, what needs to be in the CAR, when you did your offering, you had to talk a lot about what you're offering and the offering process. In general, that information does not need to be in your annual report. because you're not doing an offering right now. If you are doing an offering, like put an asterisk on that, but let's assume you're not. And so you don't need to talk about a lot of those things. However, there's a little bit of an exception. If you look at 201Q, I think it is, it requires that you describe the securities that you have outstanding, basically. And maybe when you were offering, you didn't have any securities outstanding. And you described the securities you were offering in under a different rule number. Well, now your offering's over, you do have securities outstanding, and so you still have to bring in some of that information on your some of the detail on your securities. And in a little bit, I'll go into somewhat detail about what you need to say, but not too much because I don't want to waste everyone's time and holler all the time. Because I'd love to hear about what the other panelists have to say. And then finally, your financial statements, just like in your offering, they have to be GAAP financials. Here you get a bit of a break. Depending on how much you were raising in your offering, you may or may not have needed an auditor to be involved. For your annual reports, the general rule is that they need to be certified by your principal executive officer. The language of the actual certification you need is in rule, I think 201 something, some instruction in 201A. So you need not necessarily an auditor, but principal officer certification. However, if you do have reviewed or audited GAAP financials from an independent auditor that you just have, maybe your bank requires you to get them, maybe you have them because some Reg D investor made you have them, then you must provide those. You do not have to provide the officer certification, but you do have to provide those reviewed or audited GAAPs. Okay, here's one that I love. What happens if I don't file? And I love reading the articles about what happens if I don't file. The main thing is that you cannot use Reg CF again until you are current. It's an issuer eligibility thing, and the issuer eligibility rules of 100B, like 4 or 5, it basically says that if you're delinquent, you are not eligible as an issuer under Reg CF until you provide investors with the 2 most recent annual reports that are required. And so that's the main thing. One question that I love getting asked is, will I go to jail? I love this question. Will I go to disclosure jail if I don't file my CAR? And the answer is, it depends. And not to frighten anyone, but if you just fail to file it because, oh, I messed up, the likelihood of you going to prison because you haven't made some disclosures is vanishingly slim. Remember that the SEC does not have criminal prosecution power. The Department of Justice has. So the SEC will not put you in jail if you fail to file. However, what reason did you fail to file? If it's related to fraud, now fraud can get you in jail. And so the answer is, do I go to jail if I fail to file? It depends. Don't do fraud, and the likelihood of you going to jail is low. So yeah, that's sort of the basics of what's required, when is it required, and what happens if I don't file.
Charlie, what about any private rights of action that your investors could have if you don't comply? Either your investors via Reg CF or via another round, like under Reg D, or and then there's also, if in a later round, maybe under Reg D, do you have to disclose that you failed to file?
It's a good question. I'm struggling to come up with a private, like books and records type of a right of action. I'm not saying none exist, but I can't think of one right now. Because again, it would relate absent fraud. Again, absent fraud. I can't think of a private right of action. Do you have to disclose your failure to file in another another circumstance. Again, I'm going to give you the very annoying lawyer answer of it depends. Yeah, it depends. Oh, I love this question, Jenny. Yeah, I want to avoid providing anyone with legal advice, but it's definitely it depends answer that you need to talk with your legal counsel in your Reg D or your Reg A or your public filings. Because like on the one hand, if you're becoming a 34 Act reporting company, your ability to timely file is very important to your investors. And your inability to do so in the past might be material to them. So there's one circumstance where, disclosing it may be very important. For Reg D, where there's no like ongoing reporting obligation, maybe there's less of a requirement to tell folks. Having said that, maybe your investors, you promise them quarterly updates or annual updates. And so in that circumstance, your ability to actually do that in the past can be very important. So again, it really does depend on the context.
Yeah. I would argue that it is probably material information in a later round. So it's a good reason to not be in violation of, of these requirements. So
yeah, you should. I don't think any lawyer is ever going to recommend that you make a conscious effort not to file this stuff. That would be a bad idea. You really do need to make every effort to file it.
Yeah. Thank you. Well, that's super helpful. So I want to turn to Greg, who is a professor who studied a lot about securities law, compliance with securities law, and has studied this particular issue. So Greg, can you share your findings with us?
Yeah, thanks, Jenny. Can people see my screen? So like any good professor, I have slides ready for y'all. So happy to share and answer any related questions. And I'm grateful that Charlie could kind of kick us off and establish what these rules are so that provides some context to the discussion of this paper. So if you're interested in the details of this paper, I'm going to do an overview now, but feel free to check those out there. The paper itself is on SSRN. For those who are familiar with academic research platforms. If you're not, you can also find it on my website, which is gregory-burke.com. So feel free to check it out there. Anyway, so this is a paper regarding ongoing compliance for the CAR market. And this is with myself and my co-author, Riley League, who's at the University of Illinois and fellow at the MBER. So here's a brief update on what's actually going on here for CARs. Annual reporting compliance of filing these is low. I'll give you some of those details. Issuers also have interesting behaviors. They often are filing right before a subsequent offering, which speaks to Charlie's point of kind of catching up before you issue more securities. In addition, investors are actually using this information. We find evidence that they are looking at ARs, so investors care. We do an experiment, a field experiment partnered with Kingscrowd, and that tells us a little bit about what motivates managers to comply in the first place. And we find that regulatory risk around this motivates them to comply, but potential economic upside or economic benefits doesn't really move the needle here. And so one of our takeaways from that experiment, which I'm about to show you, is that low-cost nudges such as an email can increase compliance. So let's look at some graphs. So here's the state of compliance. Specifically, we're focused on the first year after a raise happens. The idea being that that's going to be when people are most paying attention to things, when issuers are paying attention. What do we find? Less than a third of issuers are filing timely. So Charlie kind of pointed out that there's that 120-day deadline. So when we say timely, we mean by the 120 days. So less than a third are filing timely. And over half never file their first annual report. The average lag here is over that 120 days. It's about 160 days. And after a raise successfully closes, so conditioned on a successful offering, 43% of issuers we never hear from again. They file nothing on EDGAR. Now, what about like when they file things, aside from based on the deadline. Aside from based on the deadline, we also find that there's kind of this filing that happens right before a raise. So this kind of diagonal line you see here that you can kind of see there's some concentration of filings there or dots. That's just showing that there's a number of issuers that are filing right before or right around their subsequent offering that they open. So we find about 13% of them. When we condition in on those that are offering securities and have been a tardy filer, that's about a third of them. So that's kind of the state of filing. The other thing we just want to mention, we have a shout out to another paper that's related to this annual reporting requirement. We find that a lot of offerings that are ongoing close. So Charlie hasn't mentioned that yet, but a lot of offerings that are open around that April deadline will close early, thinking that they can avoid annual reporting around that period. And so this graph here shows you that uptick that you can see there is right on the April deadline. So there's a ton of closures right before that April deadline. We can use this as econometricians and researchers to think about potential funds that these issuers are giving up by closing early because of this deadline. After estimating our model and doing some work around that, basically we find that about 64% of offerings are closing 1 month earlier than they otherwise would have because of this deadline, and about a third, maybe even up to 6 months earlier than they would have preferred because of this deadline in place, which from a back of the envelope calculation, we estimate about $57 million of invested capital that is being given up because of issuers trying to avoid this annual reporting deadline for open offerings. Now, you might say, like, what's up with investors? So in terms of turning to investors' use of these annual reports. So just kind of throughout the year, and then we'll talk about within an offering. So throughout the year, conditioned on EDGAR traffic. EDGAR is the repository for all of these kind of financial documents that an investor can go to. So we have log data on EDGAR in terms of seeing traffic. So if you've been on EDGAR, I know you did it. I don't know you did it, but I know that somebody at that timestamp did it. And so I can look at that data to see, okay, what documents are people looking at? And what we find is conditioned on Form C or regulation crowdfunding related forms, about 10% is related to AR traffic. And that kind of makes sense because I think a lot of people are looking at offering documents, Form C itself, but about 10% also look at CARs. And as you can see in this graph, if we just look at the CAR share, there's a big jump that happens once a year. You can see that by those the big blue spikes on those red lines. And those red lines indicate the reporting deadline. So what does that mean? Right when CARs are getting dropped, investors are going to EDGAR and pulling them. So that's in terms of over the course of the year. In terms of investors' use of CARs during an offering, so you can imagine that there might be an offering, an issuer puts out securities, they have securities on the market, they go and have a second regulation crowdfunding offering, and so they already have some CARs in the bank, right? They've posted them in the past. And so if I want to invest in this second or third offering, I might want additional information by pulling an old annual report. And so what do we find here? Well, this graph shows where the dotted line is the start of a campaign or an offering. We can see the traffic for old ARs bumps right after following the opening of an offering, which to us indicates that investors are looking at these in times when they can make investment choices. So for issuers out there, if you're not posting CARs, that means investors are going to look for your CARs and they're not finding them. This shows that they're looking for them right when an offering is open, a time when that information is relevant because they can make an investing choice. Now to kind of turn to our experiment, this is kind of the fun stuff. So we partnered with Kingscrowd to do a randomized experiment with issuers, where we sent an email, which was functionally just a reminder to them to comply with this annual reporting mandate. And we sent 3 emails that looked like this. And the randomization was over the messaging. We randomized over messages that emphasized regulatory risk, those that emphasize an economic incentive or an economic benefit upside. And then we randomized over some discount codes for raise papers. More on that with Peyton. Given that, we were successful in at least getting those emails out. We had about a 72% open rate, which is great. So like people got the emails and looked at them. But here are the results. What do we find? Well, given those randomized messagings, we found that the regulatory risk related reminder increased compliance by about 20% off the baseline. However, the economic benefit related reminder didn't move the needle. So our takeaway from that was that regulatory risk is incentivizing for founders, for issuers to comply with this regulation. We didn't see a ton on the discount codes that might imply the cost related to preparing a CAR. But we did see a little bit when regulatory risk wasn't emphasized. In other words, there wasn't a really strong encouragement. There was some action on those discount codes. And you can see here, like going over time, each of those dotted lines is when we sent an email, and the solid line is when it was due. And this is just showing you the difference between the economic incentive group and the regulatory risk group. There obviously jumps right around our treatments leading up to that deadline. So to kind of wrap up here, kind of bring it all together for y'all, our kind of takeaways from our study is that investors are looking at these annual reports, but issuers aren't filing them largely. We find that increasing the salience of this regulatory risk for issuers so that they understand that they're required to do this and there may be some risk to them increases their reporting compliance. And another takeaway is that low-cost email. So if you're a platform or a regulator listening to this, you can send an email kind of like ours. A low-cost email is an effective tool of increasing compliance. This might be a thing that could be implemented through EDGAR with the SEC. I'm not sure how that all works. Charlie may know better than me. But there are tools that can increase compliance. And so while actual enforcement is pretty low, emails seem to move the needle and matter in this market. And so that's what I got in my initial little presentation here. I'm happy to answer questions, and I'm excited to hear what Peyton and everybody else has to say here. Thanks so much.
I'm going to bring up another compliance issue, which is that the whole thing about when you have to actually become a public reporting company. So we do have an exemption for companies that raise under Reg CF, and I'm going to read it. It says, shoot, I lost it in a second. All right, here we go. Rule 12G6 is an exemption from the registration requirements under 12G. So securities issued under regulation crowdfunding will not be counted towards the 12G record holder threshold if the issuer is current in their ongoing annual reports, they have gross assets of 25 million or less, and they've engaged a transfer agent. So the CFPA has asked the question of what does it mean to be current in its ongoing annual reports in order to avoid this potential requirement to become a public reporting company. We don't feel like that's super clear. Charlie, do you have any insight into that? And sorry, I'm springing this question without having prepared folks for it, but I think it's an important question.
Is the question is what does currency mean in Reg CF?
Right. Like if let's say you file late, but you do file your Form CAR, do you think that means that it counts as current?
Yeah, so it's the distinction between timeliness and currency. I think it only requires currency, not timeliness.
Okay. Okay. So if it,
That's
as
not the
long,
SEC answering, by the way.
right, right.
That's just Charlie.
Yeah, we are going to ask, but we have asked for some clarity around that, but that's helpful to hear that maybe even if you file late, as long as you file, you still hopefully you can avoid that requirement to become a public reporting company. But yeah, I
Perhaps,
think we
yeah.
need a little more clarity on that. All right,
Mhm.
great. And then there was a question regarding from Marco regarding why so many issuers close just before the 120th day. And that has to do with if you go beyond the 120th day, you have to have a more recent um, financial report, like the financial report from the previous year instead of the year before that. Is that right, Greg?
Yeah, so I'm not the lawyer here, but my understanding of the law would be that they would have to amend their filing by providing updated financials. So it's the two previous years to kind of continue keeping the offering open. I think, again, as the non-lawyer here, that there's a misperception that if I close early, I'm good for a year. However, those securities have been offered and sold. And so even if you close on April 20th, although you won't have to do an amendment, which might avoid doing an audit, for example. You may not have to do an audit. You still need to prepare those financials by April 30th and submit it in the form of a CAR. So
Exactly.
I
Mhm.
think that there's the only real benefit is potentially avoiding I guess the two benefits would be avoiding a potential review or an audit, as well as the additional scrutiny that might be given to the offering being open. But the requirement to actually prepare financials doesn't change if you have had a successful offering. And I do think it's worthy of highlighting this a couple of times because I believe this is actually a confusing thing for issuers. I think they think if they close the 15th of April, they don't have to worry about this until April, 30th in year plus one, the following year.
Yeah, I mean, the reason why people will close at the end of April 30th is it allows them to not have to worry about the financials for the previous year. You can have the financials for the year before that and the year before that. So yeah. So anyway, okay, let's move on to Peyton. Peyton, thank you so much for being patient. So you work with a lot of issuers and you've done a lot of you and your organization have done a lot of thinking about what is it that will get people to do better on compliance. So can you share, what do you think is the key to improving compliance? Because I do want to say that it has been noticed by the SEC that the compliance is low. It was brought up to us at our summit by one of the commissioners, and it's not a great look. So what can we do to improve compliance?
Yeah, I mean, I'll start with kind of what are a few things that are keeping founders from being compliant. And Greg, I wonder if we should use the word jail from Charlie this year in our messaging and see if that's even more effective. Um, but I think firstly, there's a general lack of education, um, really about the overall capital raising process. I think founders come in and they don't even necessarily realize how complicated the Form C itself is and that whole process. And so I think a lot of them, when they get their raise launched, it's kind of this like, oh my gosh, that was exhausting and now I'm done with it. And they kind of don't necessarily know that there is this whole phase, the post raise phase, which is the compliance, and not just the compliance, but also the continued communication with investors. So I think education is one of the big issues for founders not being compliant. Um, Another one I think is like the confusion or the lack of transparency about the rules and regulations. People have a hard time knowing those, knowing where to find those, seeking those out, unless they're very proactive, which, if we're honest, most people aren't, right? It's hard for people to really necessarily be aware of what they need to do. And then I guess I'd say a third one would be just, okay, then they find out they have to be compliant or they have to do an annual report and they get confused as to, if I launched my raise last year, this year, before April 30th deadline or the prior year, like, how do I even know what I need to do? I think those are kind of like the three big blockers for founders that we tend to see with our clients. And so I think educating founders that it's a three-phase process for capital raising. There's your pre-capital raising information that you have to get all of your corporate documents organized, what security types you're going to use, all of the terms that you're going to use in your raise. Then there is the actual raise, attracting investors and doing the raise. And then there is this post-raise compliance portion. And I think if the platforms, the attorneys, companies like Raise Papers, can really like plant the seed of this is what you need to do. It's very similar to your tax obligation. It's not optional, it's a required thing. Then I think that founders will expect it more and go into it with more of an expectation of like, okay, I've raised, but I haven't completed everything. And again, that that component of you've now raised money from these people and you want to keep them updated on how is your company doing? What has changed in the past year since your raise? Good or bad, it's equally important to communicate because that's really showing that you're a company with high integrity and that you're taking this seriously. And I think as a younger industry, we need that. We need everyone, from people like ourselves and the attorneys and the founders themselves to really hold themselves to a high standard that they want to do. And Kingscrowd has a great investor relations portal that they launched, which part of it, I think, is making it easier for founders to communicate, connect with their investors, and then to fill in the AR and do that. And so at Raise Papers, we have a filing and compliance team of specialists who work with founders to kind of hold their hand and guide them through it, let them know what they do need to do, what they don't need to do. Connor from our sales team is amazing. He's had people like catch up on 6 CARs at a time. So he's the one that will go through their history, look on the SEC, track all their filings and say, hey, you did a Form C in 2022, then you did another raise, you never finished your ARs, so this is what you need to do to get compliant. And that's a really helpful piece because if people aren't super experienced with it, they need someone to help them along the way. Let's see if there's anything else. Yeah, I would say that's about it, from a founder perspective as to why the non-compliance is happening.
Yeah. And, I imagine that there are a lot of issuers that really do want to stay in touch with their investors, but they don't want to use the Form CAR to do that because it's a clunky tool. Edgar is a hassle. How do you see how do we help folks? And you kind of alluded to this with the Kingscrowd tool that you mentioned, but how do we help folks both do a more kind of user-friendly conversational update with their investors on a regular basis and also Form CAR? Like, should those be combined? Should they be kept separate? Should they be working on them kind of all together or apart?
I mean, I definitely think this somewhat of an integrated approach is best. So there is this kind of hub, and that's really, as we evolve, what we hope to really do is, from A to Z or 0 to 100 through the whole process, be able to help people from start to finish. But I think if you have a hub where you're doing your communication with your investors, and then you can also be reminded through the data of Kingscrowd, like, hey, you're not compliant. Are Are you thinking of doing another raise? This is what you need to do. I think having that unified area for people to communicate from is invaluable.
Right. Well, we have a question. I think it has to do with having multiple related entities. And I know this comes up a lot. Sometimes people will go ahead and form like a special entity to raise for various reasons. Maybe they want to have simpler financials, so they'll form a new entity that's kind of related to the main entity. Um, and so the financials are quite simple because they just started it up. There's no old, baggage from that, and that'll be the entity that will raise. And then maybe later on they'll form a different entity and raise under that. And so there's a question about um, is there any interrelationship if you form a bunch of different entities that all do raises under Reg CF and one of them is not in compliance? Is that going to affect anything? Like, to what extent are related entities held responsible for the behavior of the related entities? Charlie, do you have any thoughts about that?
Like the first thing that comes to mind is that like for certain purposes under Reg CF, affiliates count as issuers. And so that's the first thing. Like this is a question that we can't answer on this call because we're not giving anyone legal advice. And it's like an actually tricky, really tricky question. But the first few things that come to mind are like one, all related parties are sort of treated as one party sometimes for reg crowdfunding purposes, like the amount raised. Two, like throughout the whole gamut of the securities laws, if you are doing anything to evade certain requirements, then the SEC is going to look straight through that. And so the intent behind that also matters. And so those are like the sort of first two things that come to mind. Greg could probably write an interesting law review article about this.
Yeah, that's super helpful. So I guess the answer to Cornelia is you really do want to check with your lawyer because I know Sarah Hanks, who's an amazing attorney in this space and has worked at the SEC, also has talked a lot about the concept of co-issuers, where you might think that you've created a new issuer that's totally separate from another company, but if they're so interrelated and integrated in terms of their activities, they might be like Charlie said, the SEC might look through the fact that they're legally separate entities. So something to really keep in mind. Okay, we have a question from Allison. That I think this is a challenge with Reg CF in general, which is that it does require a lot of disclosure, which can often be challenging when you want to hide some information from your competitors. So I'm not sure there's much to say about that other than, yes, that is an issue with Reg CF, but does anyone have any comments about that issue?
I think it's the reason companies don't want, one of the reasons companies don't want to go public is because they don't want to have financial information and management's thoughts on their business out in the public realm. And that applies for Reg A, that applies for Reg CF, that applies for 34 Act reporting companies. The fact of the matter is, if you want to raise using these techniques, part and parcel of that is you're going to have to be willing to talk about your business.
I think this goes back to Peyton's point too. I think when an issuer is making the decision if they want to issue securities, there's always that Reg D option, I guess, right, to avoid this disclosure problem. So ultimately, it comes down to issuers knowing what they're buying, right? Like I make sure all my students read the syllabus. Well, whether or not they actually do it is up to them, but I'm going to hold them to those rules throughout the semester, right? Those are the policies. And so before you issue securities if you can read the related requirements or speak to your lawyer that you're going to have these AR requirements going forward, and it's just up to the cost and benefits of that. So there's no surprise here. It's not like the SEC decided, after people started issuing securities, that suddenly there would be an AR requirement. It's always been there. So I think issuers just need to understand, if they don't want to prepare financials every year, then they shouldn't do a regulation crowdfunding raise. I think, and that's fine. I think there's other options that securities law allow us to raise capital. So I think that's kind of a question that issuers should think about as they go into this process. Am I prepared to prepare financial statements every year? If the answer is yes, sure, crowdfunding will be great.
And one thing we didn't mention is that you only, in most cases you only have to do it once. There's you can file something called what is it, the C dash
TR.
Yeah.
where you say I no longer have to report, and of course it depends on your particular situation, but many issuers you only have to do it once. So yeah, Peyton, were you going to say something?
I was, but Charlie, I don't know if you want to share the specific rules for that CTR.
I could look them up, but like it basically boils down to like shareholders of record and assets. I forget what the shareholders of record are, maybe less than 300 or something.
Yeah, I think it's 300. I sorry to put you on the spot. I thought
No,
you would
it's
have
no worries.
more than I did, but it's also an interesting one that we find like people will then just go, oh, well, I meet that, so I'm just going to file the TR. But in fact, you have to file the TR within 5 days of an AR. So even if you qualify, you need to do an updated AR and a CTR. And we also, again, work with founders to help them know if they need it, if they don't, when to do it, all of that stuff. But yeah, again, just another example of the little details that people don't understand or know about. Yeah, but like you said at the summit, the SEC really was impressing the importance of compliance. And so it is so important for all of us to work together to support the industry, to really, again, hold a high standard for ourselves, high integrity, and to educate and get everyone to comply. And over, I'd say, the past 5 years now, really at Raise Papers, we've just started to grow and grow that side of our business because it is so important. And to create a tool that is more simple to use and humans that you can kind of talk to about, how do I get this done effectively and easily? Because they have like post-traumatic Form C syndrome, right? So it's like, no, it's not that complicated. Let us help you just update any important things and gather everything together and kind of get it filed for you.
There's another question in the chat. So, for example, like if there is a co-issuer, like for example, let's say a lot of folks raise under Reg CF using a special purpose vehicle known as a crowdfunding vehicle. Does both the primary issuer and the crowdfunding vehicle, do they both have to file separate CARs?
I think they both file on the same one is usually how it works.
Yeah.
But they are two separate entities. They both
They
have
are.
to disclose everything. Yeah.
Correct.
Yeah.
And they would add the information of the co-issuer. Yeah, but it is within the same form, so it's not like you're duplicating. Oh, that's what I was going to say. The only kind of more additional cost is if you are getting your ARs reviewed by an attorney, your cost would go up because the attorney's reviewing for two entities versus one.
Yeah. All right. I want to take a moment to talk a little bit about Crowdfunding Professional Association. And I apologize if there's background noise. I have to be at a cafe right now. But Crowdfunding Professional Association, our mission is to help spread this knowledge and this education as much as possible. We want issuers, investors, and portals to all be as aware as possible of all the different requirements. And we also do a lot of advocacy. So we have worked very hard to come up with a list of advocacy issues that we've been talking to the SEC and legislators about. we've made some decent headway on some of our advocacy issues, but there's a lot more to go. And item number, if you know, I'll share the link to our list of advocacy issues, but basically, I think it's item number 14 in our list of issues is addressing this problem, which is that let's be honest, you know, Edgar is clunky and difficult to navigate. And so what we really we're asking the SEC to do is to try to make it a little bit easier for issuers to keep up with their annual reporting requirements. And so we've asked them if they could possibly consider creating a separate tool that would be more user friendly and also send reminders to folks before they're due. I know the portals often will send reminders, but that's a little bit less it's harder to rely on. So that is one of the 19 things that we're advocating for in our policy positions. And so I just really want to encourage folks, if you're not already a member of Crowdfunding Professional Association, I hope you will consider joining. We really are starting to get some amazing traction. We've been invited to a lot of closed door sessions with legislators. We have the ear of folks on both the House and Senate side. We have a really good relationship with one of the three, that we only have three SEC commissioners now. So we're friendly with two, I would say, but really friendly with one, which is really helpful to get their ear. We also know a lot of the staff at the SEC, plus the legislative staffers that work on this issue. So if you get involved, not only can you learn a lot of interesting behind the scenes stuff about the advocacy work and the details of what we're asking for, you can also, you know, be a part of this movement to improve regulated investment crowdfunding, which is just so important these days. I mean, there's just so many businesses that lack access to capital. And our country is going to be a much better place if we increase the number of ways and the ease with which folks can raise money from investors, obviously, while still maintaining as much investor protection as possible within, you know, balancing that with making it a little bit easier for the issuers. So I would love to invite folks to ask any questions. Oh, I see there might be some more. There's another question. Can the issuer's Form C indicate the intermediary's website as the place where the Form C-AR may be posted? No, it has to be on the issuer's website where you post your reports. You can't post it just with the portal. Any other questions? Any last words that the panelists would like to add?
Don't procrastinate. Reach out and get started on your ARs ASAP. That's all.
I agree. I think the general gist of a lot of this conversation is thinking about how to improve the industry and improve outcomes for everybody. So, you know, those outcomes being both investors having transparency of what they're investing in, as well as there being capital available for founders, right? So I think by having a more open disclosure environment where people are filing their annual reports, this will naturally, hopefully, build some trust or continue to build trust within this ecosystem. You know, and there was some commentary earlier about fear that maybe you don't have good things to say this year, right? Things didn't go so well. I think, you know, investors in issuers that are issuing crowdfunding securities understand this as a high risk environment. So I think it shouldn't be a surprise to an investor that maybe you didn't have a good year. What would be a surprise to an investor is they gave you money and then you ghosted them. And so I think being open and transparent, I think can go a long way. And it's something that may open doors for you in another venture, even if your venture fails. That you know you were the person that was compliant and continuing to issue your annual reports as required. There's nothing to hide. So, and I think investors have a reasonable expectation of performance being up and down for crowdfunding issuers. My thoughts.
Yep, I agree. I would just sort of echo what everyone's saying, that traditionally Republican administrations are very interested in private ordering and to see how the private markets sort themselves and fix themselves and regulate themselves. And so now's a great opportunity for our industry to show folks, we can do this, and don't give perhaps a different administration reasons to change our regime in ways that we don't like.
Thank you so much. Please consider joining the CFPA. It's very affordable. Just go to cfpa.org. And I'm going to ask if Brian Belay, our president, wants to add anything, if say the last few words.
No, thanks everyone. Thank you, Jenny, for hosting today. Thank you, Greg and Charlie and Peyton, for being on. Just to echo everything that was said, right? That was, I gave a presentation back in December now that was the incoming president for the CFPA and the vision for the industry. And as has already been brought up, right, the compliance is something that Commissioner Peirce had mentioned at our summit. It's something that we're thinking about because, the way I think about it, coming from a product background, right? The investors in this industry are the customers, right? They are coming in, they're investing in these assets, they're supporting the founders that they believe in. If they don't get treated with the respect and the information that they expect as investors, they're not going to come back. They're not going to be repeat investors. And it's going to leave a bad taste in their mouth. It's going to be a bad experience for them, which then hurts the industry. So the better hygiene, right, that kind of the founders and the issuers can operate by treating their investors as they should be treated, being that they've given you capital, right, I think just leaves a better perspective for the investors to want to come back to participate more in the industry, which will help to bring more capital back, which will help support more founders. So it's kind of this flywheel effect where it doesn't stop, I guess, is my takeaway, right? You raise your capital, it does not stop at that close date of your raise. Think about the post fundraise experience, how you're treating the investors and making sure that they want to come back to invest in the future. So feel free to check out that recording if you want more of that information too. You can get that on the CFPA Eco, on the ecosystem. And yeah, just want to thank everyone again for joining us today. Again, if you're not already a member, please sign up. The other thing I'll plug here is we have recently started a intermediary committee. So that's going to be one of our areas of focus as an organization in 2026 as well. So if you are a funding portal, if you're a broker dealer, if you just have input and perspective that you would like to share, please do join, become a member first. And then as a member, you get access to all the different committees that we have. And that intermediary committee has already been meeting, lots of good discussions there. So I will end it there. But if there's anything else any of the panelists want to say, and we thank everyone for your time.